I'm going to be talking about important brief in Under-21 case filed in federal court. This was filed September 19th, 2025, and the case is Reese versus the ATF, and it challenges the prohibitions on 18 to 20-year-olds from purchasing handguns. They were victorious at the Fifth Circuit. They're now working towards a final judgment at the district court level. Reese versus ATF involves the named plaintiff, Caleb Reese, as well as three organizations: the Second Amendment Foundation, Firearms Policy Coalition, and the Louisiana Shooting Association. The U.S. Fifth Circuit Court of Appeals ruled in January that, and quote, the Second Amendment includes 18 to 20-year-old individuals among the people whose right to keep and bear arms is protected, end quote. The government did not seek review at the U.S. Supreme Court, and the case has been since remanded back to the district court for a final judgment. Plaintiffs made a, end quote, good faith attempt to reach an agreement with the government, but they failed. Plaintiffs argue that the prohibition on the sale of handguns to those under 21 should be enjoined for all of their members. The government contends that the judgment should be narrow, applying only to the named individuals in the suit. Speaking on behalf of the Second Amendment Foundation is Bill Sack, their Director of Legal Operations. Mr. Sack had to say about the situation, and quote, what's at stake now is the scope of the injunction, meaning what young adults will be able to exercise their rights. Although it chose not to appeal the Fifth Circuit's ruling, it is now the ATF's position that the scope of relief should be so narrow as to cover literally no one. That position is contrary to the well-settled law. SAF sued on behalf of its members, and the relief SAF won in the Fifth Circuit flows to those very members. All SAF members should be covered by this injunction, end quote. Also speaking on behalf of the Second Amendment Foundation is founder and executive vice president Alan Gottlieb. Gottlieb said, SAF's victory in this case rightly applies to all of our members, and that is precisely what this brief makes clear. The government cannot continue to trounce on the Second Amendment rights of young adults by trying to avoid the practical effectiveness of an injunction mandated by a federal circuit court. One of the other plaintiffs in the case is the Firearms Policy Coalition. Their president, Brandon Combs, had this to say: the DOJ's cynical scheme to undermine associated standing and relief for our members is nothing but an attempt to put constitutional accountability out of the reach of ordinary Americans. The federal government, having lost on its merits, is now trying to rig the process, but we will not be deterred. While the government has placed FPC and our members in its crosshairs, we are proud to expose and oppose this dangerous strategy as we pursue a world of maximal liberty for all peaceable people. It's been alleged the most pro-Second Amendment administration is in power. The government yielding by allowing the clock to run out on appealing to the High Court certainly was a win for advocates. However, if in the next breath they're saying that the relief Reese et al. Seeks should be grossly limited, that's not aligned with what activists considered being true to the right. Proponents contend the Fifth Circuit was clear when it said that 18 to 20-year-olds are part of the people, and there should be no further argument.